Good evening and welcome. My name is Jacob Begard and I'm the Program Manager of the Common Ground Initiative in the Hauenstein Center for Presidential Studies. On behalf of the Hauenstein Center, the Gerald R. Ford Presidential Foundation, and the Gerald R. Ford Presidential Museum and Library, thank you for joining us for our inaugural virtual Common Ground Initiative program. If you're new to Zoom, welcome. You'll find a toolbar at the bottom of Zoom that allows you to ask questions throughout the program tonight. Simply type in your question and submit. Here at the Hauenstein Center, we have a mission to do 4 things. First, we deliberate on the presidency and try to learn the lessons of the history of the occupants of that office. Second, we debate the most nettlesome issues of our day in our Common Ground Initiative. Third, we develop the next generation of leaders in our Peter C. Cook Leadership Academy. And fourth, we disseminate the wisdom drawn from the life and legacy of our namesake, Colonel Ralph W. Hauenstein. This past summer, after 17 years of service, our founding director, Gleaves Whitney, retired from Grand Valley and stepped into the role of executive director at the Ford Foundation. But don't worry about missing Gleaves. The Hauenstein Center and Ford Foundation will continue to partner on great events, such as tonight's. If you were hoping to see and hear from Gleaves this evening, well, you're in luck. Gleaves will be Professor Monopoli's interlocutor for this evening's program. Tonight will play out as follows. We will begin, as always, with a leadership minute from one of our fellow candidates in the Cook Leadership Academy. Next, Professor Monopoli will begin with a 10-minute overview of the context for her book and this evening's conversation. She'll be joined by Gleaves for about a 30-minute discussion of the book. We will close with questions from the audience. So please begin submitting your questions using the Q&A feature at the bottom of the Zoom toolbar as they come to mind. I would like to now introduce Camila Russo, a senior studying political science and nonprofit administration. This is Camila's second year in the Cook Leadership Academy, and she is also one of our inaugural lead fellows in this year's cohort. Take it away, Camila.
My name is Camila Russo, and I'm a Cook Leadership Academy fellow candidate. I like to define myself as a busy bee. I'm the kind of person who jumps on any new task, project, committee, or organization before even considering if I actually have time for it. For every new activity I pick up, I divert my time and energy away from the several different projects I'm already working on. And then there's school and work, and don't forget about sleep. My attention becomes divided and my leadership ineffective. CLA has helped me realize that sometimes it's more impactful to focus all my attention on a few projects that matter without overextending myself. Despite how painful it can be to turn down that really cool new idea, I've learned that it is okay to say no. And it does not make me a bad leader or a bad student to turn down that new project. In addition to learning how to say no to new projects, I've also been working on how to say no to myself and how to step back and delegate. Often, I find it easier to do things myself rather than train someone else to do the job for me, then having to ensure that the project is done well and on time. This requires trust and relationship building, and I'm not always willing to take the risk that things may fail. What I was learning in Cook Leadership clicked when Dr. Boone, Grand Valley's housing director, described leadership as the ability to empower and train others to do your job so that when you leave, you can be confident that your organization is in good hands. I thought leadership meant being the best within the field, the loudest voice, the one always doing everything. But through Cook Leadership, I learned that leadership is just as much about listening as it is about speaking and empowering others to share their stories and ideas. It is not only about getting the job done, but it is also about trusting others to take a project into their own hands and empowering them to shape it in accordance to their abilities. It is not about having a title or a position, and while leaders should challenge themselves and develop their skills, it is just as important to develop the skills and growth of the team. I've learned this from observing the leaders around me, who through the recognition, trust, challenges, have empowered me to grow, develop, and lead in my own way. My name is Camila Russo, and I'm a leader.
Thank you so much, Camila, for that wonderful testimony of how you've grown in your leadership. So proud of you at the Cook Leadership Academy. Been proud to work with you. And now I have the distinct privilege, the honor of introducing our main guest this evening. Paula Monopoli is the Saul and Carolyn Hubert Professor of Law at the University of Maryland's Carey School of Law. She also holds an appointment as a visiting scholar at the Moeller Institute, that's in Churchill College at the University of Cambridge. An elected member of the American Law Institute, Professor Monopoli received her BA from Yale College and her JD from the University of Virginia Law School. She is the author, editor, or co-author of 3 previous books, American Probate, Law and Leadership, and Contemporary Trusts and Estates, as well as being the author of a number of articles, including Gender and Constitutional Design, which was published in the Yale Law Journal. Now we're going to be talking about her most recent book, The Constitutional Orphan, Gender Equality and the 19th Amendment. And in it, Professor Monopoli explores the significant role of suffragists in the constitutional development of the 19th Amendment, the Women's Suffrage Amendment ratified in 1920. She sheds new light on the suffragists as institutional actors. Well, in this compelling legal history, Professor Monopoli illuminates how the 19th had implications for federalism, women's citizenship, and the definition of equality, as well as how gender, race, and class affect our constitutional development. Now, it's gotten some rave reviews, this book. Let's take Reva Siegels from Yale Law School. She said, in this path-breaking new book, Paula Monopoli bridges conversations in history and law to ask why the 19th Amendment has been overlooked and become a constitutional orphan in the Constitution's interpretation. Her magnificent recovery of this history will enable the amendment's more robust interpretation and enforcement in the years ahead. Well, Paula, thank you so much for joining us this evening.
Thank you, Gleaves. I'm really honored to be here tonight to help the Hauenstein Center celebrate the Constitution and Constitution Day, and to talk about Constitutional Orphan. And I really appreciate the invitation. It's terrific.
Well, it's just great to have you.
Thank you.
So my first question, I think the professor at Yale Law School actually sets it up quite well. It's a great title. It's an eye-catching title, Constitutional Orphan. Why did you choose that title? Unpack that title for us.
Well, I think that the two most important things to think about when I was sort of choosing the title, first was the idea that the suffragists, as you said, were institutional actors in this story, right? And so they were so instrumental in creating the push over 72 years for a federal suffrage amendment. And there's a long history of that. And they achieved that goal in 1920 and then turned immediately to other things. So for example, they turned to the Equal Rights Amendment in one case. One of the more militant group did that. The other group became the League of Women Voters and turned to education and social welfare legislation. So that's the first meaning of constitutional orphan, was that pivot away and the sort of leaving it unadorned, undeveloped. The second meaning is essentially that it then became rarely cited by courts in the United States. And in that regard, the sort of important comparison, for example, is that the 15th Amendment, which looks textually very similar, was cited more than 2,800 times by courts, state and federal courts. The 19th fewer than 700 times. So there's a distinct difference in the fleshing out, if you will, by the courts and the attention paid to the 19th Amendment. So that's the sort of second import of the meaning. And I think that, you know, we can talk some more about the consequences of that. And I think that, you know, if I can introduce some of the women who were instrumental in that, it will help give some context here.
Well, Paula, I think that's a great way to set up your slideshow now that we understand why that interesting title. So please take it away.
Great. So the first slide here that I've got up, the first photograph, in terms of those women who were so instrumental, as I just mentioned, in getting the 19th Amendment, the federal amendment, over the finish line. This is Alice Paul. And Alice Paul's a very central figure in this story. Alice was a young, from a Quaker family who traveled after she graduated from Swarthmore to England. And she sort of learned at the feet of the British suffragists about militant suffrage activity. And she came back to this country and joined the National Association, the National American Women's Suffrage Association, Women's Suffrage Association. And in doing that, she was young and she was a little impatient. And the older women in the National, as they called it, wanted to sort of go state by state in terms of moving suffrage along. And that basically was kind of anathema to Alice. And so she split off from the National, from the more conservative mainstream organization. And when she did that, she essentially formed the National Woman's Party. And the National Woman's Party began to agitate for a federal amendment. That was their major mission. And so they picketed the White House even during World War II, which even the British militant suffragists hadn't done. And so in that way, they were very activist. They were jailed. They were force-fed at the district jail in Washington, D.C., and at the Occoquan workhouse, which is a little bit south of D.C. and down in Virginia, where they're building a national monument right now to the suffragists. And they were political prisoners, and they viewed themselves that way. But that final push, that generated a lot of very negative publicity for the president, for Woodrow Wilson, according to many historians, at least helped accelerate the final ratification of the 19th Amendment. So she played a very central role in this. And she did get, well, it depends on which historian you talk to, but some think that that's what made Wilson switch his position and support a federal amendment, which he had not previously. And then the next slide, please. And another really important figure is the African-American suffragists. And in this commemoration of the 19th Amendment, which is what I call this kind of time that we are looking at all of the implications of the 19th. I don't call it a celebration because we have now, I think, discussed a lot more the kind of racism that was perpetuated in the movement. And Ida B. Wells Barnett was an African-American suffragist, and they played a very important and forgotten role in the story of the 19th. So Ida B. Wells was a journalist. She was an anti-lynching and suffrage advocate. And when Alice Paul was still with the main organization, Alice Paul organized a massive parade down Pennsylvania Avenue. It was the day before Wilson was to be inaugurated in 1913. And Ida B. Wells planned to march with her delegation from Illinois. And she was the head of the Out for Suffrage Club. However, they were told that it would be better for them, or they should, march at the back of the line. And so Alice Paul begins to show this kind of concern for alienating Southern suffragists and eventually Southern congressmen by sort of engaging in this kind of structural racism, if you will, and telling Ida B. Wells that she had to march at the back. Ida B. Wells did not. She waited for the parade and she joined in with her Illinois delegation. But these women, again, were sort of beginning to show this implication that I talk about in the book. Since the book focuses after 1920, we see the rise of that split and the impact of that racism, not only as a moral failure, but as a strategic failure. Next slide, please. And another very important African-American suffragist was Mary Church Terrell. Mary Church Terrell was the first president, leader of the National Association of Colored Women, the NACW. She was a suffrage and voter education activist. And after the amendment was ratified, Mary Church Terrell went to Alice Paul with a delegation of women when the National Woman's Party was deciding what they were going to do now that they had succeeded in getting the 19th ratified. And in 1920, the November presidential election, African-American women were turned away, even though the 19th had been ratified, and by law, they should be allowed to vote. They were turned away in significant numbers, in some states in the North, but in many states in the South. And so Alice Paul, Mary Church Terrell asked her for her help, for the resources of the suffragist party, the National Women's Party, to go down to the South to push for a congressional investigation of this voter suppression in the South. And Alice Paul made a tactical move, split race and sex, and said, our issues are about sex, that's an issue about race, and failed to essentially join with African-American suffragists to remedy that. And she failed to support enforcement legislation, which I'll talk about a little bit later, but that's Marriage Church Terrell. So these women were all interacting, these suffragists from different groups interacting. And then the last slide. And then this is Florence Kelley. And Florence Kelley was a lawyer. And again, we don't think of women lawyers too much in that period, but she was a very, very veteran litigator. She had been very involved in the, with Louis Brandeis in the case of Muller versus Oregon in 1908, where they filed what we call the Brandeis brief in law, which was the first brief to actually include empirical evidence of the poor working conditions around factories and labor. And so she had been involved in that case. She was a litigator. She was also a co-founder of the NAACP, and there were several suffragists, Mary White Ovington, Florence Kelley, who were co-founders of the NAACP. And they stood with women like Mary Church Terrell in sort of pushing Alice Paul at that 1921 meeting when they were deciding what the next step was for the National Woman's Party to join and to help fight the denial of the vote to African-American women in the South. She fought for protective legislation for women, minimum wage, maximum hour legislation for the horrendous conditions that working women and poor women faced in factories. And Florence Kelley was committed to that. And so she, after the 1921 meeting, Alice Paul decided her next mission was going to be the Equal Rights Amendment. Florence Kelley feared that. She feared the conservative Supreme Court would use an Equal Rights Amendment to strike down legislation that gave women a different treatment for minimum wages and maximum hours. And so that split really was had a profound impact on the 19th. Again, I talked about the suffragists turning away. They also got embroiled in this dispute, and that really minimized the development of the 19th Amendment. So as Gleaves said, this implicates federalism, the scope of women's citizenship, and the definition of equality. What is equality? Is it essentially everything absolutely the same? No difference in law between men and women? Or is it making sure that women who might have been behind the starting line are brought up to that starting line, a more affirmative vision of equality? So in 10 years after ratification, when we look at what happened, and these women were all engaged with each other, we see that there was a very narrow understanding of the 19th Amendment, which basically provides that the states cannot abridge or deny the right to vote. And so the court's understanding, although it was contested, and that's the focus of much of my book, is that it was dominantly simply about the vote and not about more, not about political freedom and liberty, holding public office, jury service, which were also viewed as political rights. And it was lost to our collective memory as Americans.
Very good. Thank you for that wonderful slide overview, because I think it gives us a sense of the people, the characters, the character of these women who were so determined to make this a urgent agenda in the American polity. There seemed to be a lot of misconceptions about the 19th Amendment and women's suffrage. One of the fascinating things, I think, for people who live in the West, especially around Wyoming, they love to point out that Wyoming actually gave women the right to vote in 1870, 50 years before the 19th Amendment. So what do you say, Paula, when you hear people ask the question, did the 19th Amendment give women the right to vote?
It's a great question, and it is, Wyoming is to be lauded when it was a territory, right, for being the first to give women the right to vote. And I think Utah claims that even though they followed, I think it was the next year as a territory, the first woman to actually cast a ballot was in Utah. So there's a little interesting rivalry between the two states there. But and then, of course, there's a fascinating history in Utah of losing the vote and then coming when it came back into the Union of the state. So the first section of the 19th Amendment is essentially a prohibition on states. It also includes the United States, but dominantly, right, they were concerned about states So it says the right of citizens of the United States to vote, shall not be denied or abridged by the United States or by any state on account of sex. So that's clause 1. So that's not an affirmative right to vote. In fact, there's not an affirmative right to vote for anyone in the Constitution. The right to vote, if you will, or the privilege of voting is left to the states by the Constitution, unless the federal government decides, Congress decides that it wants to speak, that it wants to legislate, either by amendment or by law, by statute. So it did not give women the right to vote in that sense. It was a protection against states denying them the right to vote solely on their sex. States retain the power to control the eligibility to vote for lots of other reasons, but that's basically the import of Section 1. Section 2, which is rarely described when you read the articles about the 19th this summer, when we're commemorating the 19th and the 150th anniversary of the 15th Amendment, which looks textually almost verbatim, except it, of course, prevents the states from denying people the right to vote based on race and ethnicity, right, and previous condition of servitude. So it's really that Section 2 gives Congress, it says Congress shall have the power to enforce this article by appropriate legislation. That's a powerful tool on the part of Congress. And it's an interesting story. Essentially, the amendment just struck the word male in the state statutes that it applied. So if it had if a state statute or a state constitutional provision had the word male before the word elector, it's as if someone came with a pen and struck it out, even though they didn't. That was the impact of the 19th. But the enforcement power, which had been used under the 15th, of course, after the Civil War, many force acts were enacted to go and actually try people who denied African-American men the right to vote. The enforcement clause of the second, which was contested when it was being debated in Congress, and there was actually an amendment to kind of water that enforcement clause down and say, well, the states shall have the power to enforce. And if they pass any law that's in conflict with this article, then Congress can step in. That was not adopted, right? So we have a very powerful enforcement clause, which was not used. The problem is what you see there is just what I mentioned when I was talking about the African-American suffragists like Ida B. Wells and Mary Church Terrell. You saw de facto disenfranchisement of African-American women despite this prohibition in Section 1. And you did not see enforcement legislation come out, even though it was introduced into Congress, out of Congress to help with that disenfranchisement. And then, of course, Native American women were not citizens in 1920. Native Americans did not become citizens until federal legislation was passed in 1924, so they couldn't vote. Asian immigrant women could not be naturalized in this country because of things like the Chinese Exclusion Acts. And so it wasn't until the 1940s and 50s that Asian immigrant women could be naturalized. And, if you're naturalized, you can become a citizen and then eventually vote. So, and Latina women faced, in some parts of the country, faced the same sorts of de facto barriers that African-American women face. So when we say, did the 19th Amendment give women the right to vote? It did not give an affirmative right. It did enable millions of women to vote eventually. But that's a long story and again, an intersectional kind of story.
And these are crucial distinctions to make. And, you teach legal history, and you teach, in essence, American history through legal history. So you must encounter a lot of misconceptions or just things that people don't know that you think they should know among your students and also in your media inquiries where you would like to have a broader audience understand the importance of the 19th Amendment to American life and culture. What are 2 or 3 things that you always make sure, in addition to all the other very rich things that you're talking about, what are an additional 2 or 3 things that you really like to hit so that students and the broader public understand the importance of this amendment?
So I think what I just mentioned, Gleaves, is a really important thing for Americans to understand, right? That there is no affirmative right to vote in our Constitution. And so I think there is actually in some state constitutions, but not in our federal Constitution. So talking about the language of voting amendments like 15 and 19, 15th Amendment, 19th Amendment is important, and getting people to understand how our Constitution works that way. It was almost as though the Constitution was retrofitted by these voting amendments. So when the 15th, right, when we started, we had essentially only white men who were property generally could vote. Although there was a little period actually in New Jersey where women were voting and nobody seemed to object. Then they got that right taken away. But then we sort of, until 1870, when you get the 15th Amendment after the Civil War, that expands the polity. The people, right, we live in a participatory representative democracy. The vote is the ticket to participating in that. So we expanded to include African-American men with the 15th. We then expanded in 1920 with the 19th Amendment by almost doubling the electorate. I mean, it's a huge moment. And Camila Russo, a constitutional scholar who's at Yale Law School, has called it the biggest democratizing event in American history, because the other events maybe enfranchised hundreds of thousands. This enfranchised millions, right? So it's a huge moment that way. And then we have other voting amendments. We have the poll tax to prevent people from being denied the right to vote because they can't pay a tax in the 24th. And then we have 18-year-old voting, again, enfranchising people between 18 and 21 and the 26. So there is no affirmative right to vote in the Constitution. That's what I want people to know. But we do have this constellation of voting amendments, which the trend has been to expand the polity, right? To make it bigger and to make participation broader. So that's important. The other thing is the American suffragists wanted to be called suffragists and not suffragettes. And I see this a lot in the popular media. And the story about suffragettes is the British militant, the Pankhursts, Emmeline Pankhurst and her daughters, who Alice Paul worked with and learned at the feet of, were called suffragettes as an insult. It was the diminutive form, right? They embraced it though. They took it on. They're like, great, we're the suffragettes. And again, they had a group of more conservative suffragists that they were distinguishing themselves from. The American suffragists didn't like the phrase suffragette. Again, they did understand that it was sort of to diminish them. So that's another thing that I sort of try to remind people when I'm talking to people in the press and things about what's the difference there. And I think that's kind of a fun and important thing. The other is, as you mentioned, when you asked about, Wyoming, women already had the right to vote in 15 states before the 19th Amendment was passed, full voting rights for presidential elections, for congressional elections, for state and local. There were 12 more that had a partial where they could vote for presidential elections. So by the time the 19th Amendment is enacted and ratified in 1920, women could vote for the majority of electors in the Electoral College for president. So I think that's something that people don't understand. It didn't just kind of come full blown at one moment in 1920. It was a hard fought 72-year battle where they had made incremental victories along the way. But again, that conservative National American, the conservative women's group, had pushed that state by state strategy, again, in part because it appeased, if you will, Southern congressmen, Southern voters, Southern suffragists who were worried about federal control over elections that would mirror what happened after the Civil War and Reconstruction. So those would be the things that I would say are kind of interesting.
Well, Paula, you have engaged in such an important act of historical recovery. And I'm curious what you think, what would be the reason why more Americans do not know this fascinating and really essential part of our history? Why don't we do a better job teaching it in our schools, exposing people to it? What are your ideas about that?
So I think that we didn't control the narrative, Gleaves, right? So women were not historians in large numbers. They were not academics in large numbers. And so the people who write the history control the understanding. And I think for many years that was really true and again, as a law professor, I'm just in awe of the historians. So there were women in the 1960s and 70s who became historians who were told, don't bother with this history, it's not important. And again, we have debates, you as a historian, I'm sure have had this conversation, right, about the great man theory of American history, right? And so it kind of is, I think that it implicates that. But there were these women historians in the 60s and 70s who were grad students who said, you know, I'm going to be courageous enough to make this my calling and to make this my field. And so, you know, we have historians like Anne Gordon who were, you know, surfacing this history, Ellen Du Bois, in the 70s, and brought us these amazing sorts of histories and stories. And people like Rosalind Thorburn Penn, who, like Anne Gordon, had surfaced the history of the African-American suffragists. And that's just incredible. And so in our field, in law, you know, Reva Siegel wrote an article 20 years ago and said the 19th, you know, has sort of been under-theorized and underutilized. And so let's talk about all of the ways in which it could be read together with the 14th Amendment. And for many of us who are law professors, that was just a revelation. We didn't learn about the 19th Amendment in constitutional law class, you know, and I graduated in the 80s from law school. So it's not that long ago, but we have wonderful historians today, wonderful, you know, legal historians, historians like Kimberly Hamlin, whose book Free Thinker is a great book about Helen Hamilton Gardner, who was the NASA lobbyist, who was very friendly with the Wilsons, and the role that might have played, right, in getting this over the finish line, the 19th Amendment. And then young legal historians like Elizabeth Katz, who's writing about the whole history of women kind of holding public office, which predates 1920. And again, you're going state by state. So states had different approaches. So, you know, we forgot about it. But now I think this has just been a wonderful commemoration, a wonderful year of commemoration, sort of bringing it back and surfacing that history. So I think that has a lot to do with it. I think some of the things I point out in my book, the fact that there was no enforcement legislation that kept it out of the federal courts, and it kept it in the state courts, where they kind of cabined it. And you can understand how state courts would be concerned about giving up state sovereignty. They were not the likely sort of courts to broaden the impact of the 19th. That would be a federal court, right? Which would give it more oomph. And then the fact that enforcement legislation was defeated, or died in committee, essentially, is an important piece of this puzzle too, I think.
Paula, how do you think the 19th Amendment matters to us today? Why should we be studying this amendment? How could it be applied today?
I think that the way I like to think about it is that the 19th, if we were to, again, kind of amplify it, right? Maybe give it some broader interpretation, and also maybe eventually pass enforcement legislation pursuant to Section 2, has an expressive dimension. It reminds us in our history of that 72-year collective popular debate. If you look back, and one of the best things about this book, writing this book for me, was the ability to sort of sit and read personal letters, to read, you know, articles. The New York Times, for example, virulently anti-suffrage, which is really fascinating. So there was this huge popular discussion among, you know, millions of Americans about the wisdom of this amendment. And, you know, again, we don't have an affirmative right to vote. We don't have, in newer constitutions in other countries, there is often a gender equality provision. We don't have that. This is our commitment to giving women equal citizenship and giving them equal participation in governance. That's what the 19th Amendment is. So I think today, sort of reminding people about it is important for that reason, that women were explicitly, and we committed to making them equal citizens. And again, depending on who you talk to, that meant political freedom, political liberty, or maybe even more than that. And the fascinating thing about the 19th to me is when you read the contemporary writings, the suffragists seem to try to, at least in public, narrow the implication, saying that we want political liberty. We want the vote and jury service and holding public office. The anti-suffragists were actually perhaps more reflective of maybe what the suffragists really hoped for, which is it's going to upturn the natural order of things. It's going to let women go into the public sphere. And, you know, this is a terrible thing for the family. I think perhaps that's what the suffragists hoped, right? But they were politically savvy enough to suggest, oh, it's limited to political liberty. But I think that those are important things to remember today. And the other thing is, if we were to engage perhaps in adding a new piece of voter rights legislation pursuant to Section 2 that helps protect against abridging votes because of sex, or we were to amend the Voting Rights Act. The Voting Rights Act prevents abridging the right to vote based on race and ethnicity, but it doesn't prevent states from abridging the right to vote based on sex, which is an interesting difference between that and, for example, Title VII of the Civil Rights Act, which preceded it by a year. So, you know, those could help us enhance voter access. And I think that's the message that I like to get across is clearly, again, the trajectory, you know, constitutionally has been to expand the polity, and that we should be making voting accessible for people, and that we all understand that women have still have a disproportionate responsibility for childcare. It's empirically clear from a lot of the evidence, and things like elder care. So voter access is important, and being able to use the 19th to help protect the ability to vote, not just on one day at one time, especially, you know, because women are disproportionately affected by rules like that because they are the childcare. They are the people who are in charge dominantly of childcare and elder care and things like that. And also issues around the gender pay gap. Women earn less than men. So things which require expenditures of money in order to vote also disproportionately impact women. So there is a role there for the 19th. It's not clear whether the 19th, again, as unadorned as it is sufficient to help get that done. It might require enforcement legislation to do that. That's an interesting legal question. But I think that's, again, the power of the 19th today.
Let's go back to the context. Let's go back to 1920 and a presidential election that year. And you'd had President Wilson, and then in 1920 you have Warren Harding, who's a pretty conservative guy, a Republican. And the irony that historians have noted is that a lot of Republican women voted for Warren Harding at the very same time that there was so much support for the 19th. How do we explain that?
Yeah, it's again a really interesting. History moves, I think, in fits and starts, and so you know it's sort of 2 steps forward and 1 step back, right? And so it's an action and then a reaction. And I do think that the period leading up to 1920 was amazing in terms of constitutional development generally, right? So you've got the 16th Amendment, you've got prohibition, right? The 16th, the 17th, the 18th, the 19th, they're all passed within 10 years of each other. And so it's very active. You've got World War I and the implications of that for the country. You have the deep fear of socialism and immigrants generally. And I think that that's an important, that was just, it tore the country apart. We had the trial of Sacco and Vanzetti, which Felix Frankfurter, who plays an interesting part in the story with Alice Paul of battling against the ERA. He was allied with Florence Kelley. And so those all, I think that kind of, the country was exhausted perhaps by all this, right? And, that return to normalcy that Harding represented, I think perhaps explains part of this. The other really interesting part for my students that I sort of emphasize is 1920, Alice Paul pivots and then puts the Equal Rights Amendment into basically starts drafting the Equal Rights Amendment. It was Republicans, Alice Paul was essentially a Republican, right, who had supported the push for the 19th in large part. They had to drag, Woodrow Wilson, get him to switch positions. Republicans had supported her in the 19th, and they were supportive of her in the Equal Rights Amendment. So once the Equal Rights Amendment went into Congress in 1923, and it didn't come out until 1972, again, I attribute that in part to these battles and the splits in the movement, and I think that's important. After that, it was the Republicans who supported the Equal Rights Amendment all the way up through the 1960s into the 70s, right? And then there was this flip, and you get Democrats supporting it, and that tracks, right, all the other streams going on in American history in terms of where the Republican Party sat and the Democratic Party and the switch. So that's, I think, a really interesting part of this. But you know, I do think the country was probably exhausted by that point at all of the things, you know, that had gone on. And so this was just, again, return to normalcy.
Paul, I have a couple of questions now of a little bit more personal nature. As I look at your book, I'm charmed actually by the fact that you dedicate your book to family, including your mother, and you acknowledge her critical reading of your manuscript. Tell us about her way of forming you and her role in this.
Oh, I'd be happy to. So my mother was the child of Irish immigrants. So she was first generation American, grew up in Providence, Rhode Island, and again, very poor, and worked her way through college to become an English teacher and a history teacher. And she went to Brown to get her master's degree. When she met my father, they both went back for their master's degrees, he in engineering and she in history at Brown, and was just fascinated by the courses and delighted to be there. And she was expecting me at the time, and one of her professors told her that she was taking the place of a man in the classroom. And, you know, that was devastating to her, right? She was interested in this and just delighted to be there. And so I think perhaps I heard that somehow, and so she was always committed to, you know, she loved history. And so we were all very imbued in history, and we traveled and were given, you know, the history of each place we went to. But she always was also committed to women's equality and to how important it was for women to have agency and to be able to act on their own, to be able to support themselves. And again, a lot of that came from my grandmother, having worked very hard as an immigrant. And so she shaped my love of history. And I didn't have any lawyers in the family. Teacher and engineer. My dad was a professor though, so the teaching kind of, you know, I think kind of came through, and that shaped me as well. But that's where the real interest in history and women's equality comes from.
Well, I also know, I've got to ask you this. I think many of our viewers want to know. We're all really thinking a lot about what Ruth Bader Ginsburg meant to us. And I'd like to know what you think.
So when I think of Justice Ginsburg, I think of the fact that before she was Justice Ginsburg, she was Professor Ginsburg. And she often spoke over the years about, she said, I spent 17 years of my life in the law as a law teacher. And she was very proud of that. And she pioneered, not only was she one of only 30 women, tenure track women across the country when she joined Rutgers faculty in 1963, there were 30 women and there were 1,200 men across the country. So she was a pioneer that way. She also helped the students begin the first law journal that focused on sex discrimination, the Women's Law Reporter. And she taught the first seminar in women in law. And she put out the first case book in sex discrimination. And so in that regard, you know, she was creating a field of study. And that's an amazing thing, right? It didn't exist. And the students were so grateful because they said the faculty ridiculed us when we suggested a law journal about gender and sex discrimination issues. So I think that's a really important thing to remember too, is that shaped so many generations of women, lawyers, students, law professors, who then went out and, you know, began to sort of pursue this field and understand how the law worked to shape gender equality or to thwart gender equality. So she was a pioneer in so many fields. You know, we've heard a lot about her advocacy in front of the court and the cases that she brought and the law that she created under the 14th Amendment for equal protection for women. And that's critical. And obviously her, you know, standing as a justice is enormous. And I think of I was lucky enough to bring my class down to meet her several years ago. And we met her in the court in one of these beautiful conference rooms in the court. And she, again, always teaching. She taught my students that day about the history of the Supreme Court, the building. And she wanted them to know that it was a woman lawyer. It was the lawyer for the National Women's Party, who negotiated the sale of that property which had been the National Woman's Party, the militant suffrage headquarters, sat on the parcel where the current Supreme Court now sits. And the government wanted it for the new Supreme Court building. And so there was a condemnation proceeding, and Bernita Shelton Matthews, as Justice Ginsburg taught my students, negotiated the largest condemnation award in the history of the American government, I guess, at that point. And she was so pleased with that and wanted the students to know that this woman who was a lawyer in the 1920s had done this incredible job. And I think that she, as she sat in her chambers in that new Supreme Court building, which was opened in 1935, and as Justice Ginsburg sat there, somewhere in her mind were those militants, knowing that those militant suffragists had been on that spot, right? And they took that spot because they wanted to oversee Congress, keep an eye on Congress. So, you know, she means so much. We are in such debt to her for, you know, all of those things. And she just will be so, so missed.
Well said. Well, I know we have a couple of people who want to ask questions. Before we get to those questions, I just wanted to give you the opportunity. Is there anything else you would like to cover at this point before we go into the audience questions?
Yeah, I think that for me, again, from historians like Rosalind Terborg Penn, the issue of how much of a role race played in the story of the 19th is that, for me, was the dominant lesson that I didn't understand. That I did not understand how important the 15th was to the 19th. The Congress had the 15th in their mind when they were shaping, and that pushback against the 19th came from Southern congressmen who were, you know, deeply concerned that it would operate like the 15th had operated in Reconstruction, and we'd have federal troops and federal trials, you know, down in the South. And so that, when I finally understood that, I think it's the key to understanding that, you know, constitutional moment that Alice Paul missed when African-American suffragists said to her, all right, we've got the 19th, but it won't mean anything. It will be diminished in its effect, is what they said, if we don't have your help in helping us fight back against being disenfranchised in the South. And she turned away at that moment, and I think that had so much consequence for the underdevelopment of the 19th at that moment. So again, it's not only a moral failure, it was terrible moral failure, but a strategic failure in terms of her mission to, you know, sort of amp up or get the 19th as powerful as it could be.
And we're still reckoning with that today.
Absolutely, right? And I think that that's so important, and that we learned that lesson, that solidarity matters. And if we want to achieve that goal, that we have to have common ground. I mean, I think that's what the work at the Hauenstein Center is about too, right? Bridging those gaps, acting in solidarity with all women now, today, in 2020, is so important. And that lesson is there in 1920. And so if we forget it, we forget it at our peril. And so I think that, I hope my book makes the point that today we do need to remedy that, right? That structural racism, and work together as allies.
We've got some great questions coming in, Paula. One of them, what challenges to the 19th do you think would have to arise which would lead to the amendment needing to be cited?
Oh, interesting. So the only case, federal case, which actually analyzed whether or not a state law violated the 19th Amendment was a case back in 1937 that had to do with women getting an exemption for poll tax registration and men not. And so it was actually a man who brought the challenge and said, this violates the 19th Amendment because it says the states cannot deny or abridge the right to vote based on account of sex. And so that's a really important thing for everyone to remember. It didn't give women, it didn't give women the right to vote anyway, but it doesn't specify women getting the vote or not denying or abridging it because you're a woman. It's because of sex, or on account of sex is the actual language. So cases that might arise, right, could arise from men who say there's a disparate impact on me as a man because of a particular state statute that abridges my right to vote. So, you know, there are cases pending now where there are interesting questions about this in terms of state statutes which require re-enfranchised people who had committed felonies who are now being re-enfranchised to pay every last penny of fees and fines. And so, you know, there's an argument that that disproportionately affects women because they have the gender pay gap. But there could also be, you know, a sort of an intersectional argument about race and gender there, but also it disproportionately affects African-American men because of incarceration rates. So, you know, we shouldn't forget that the 19th says on account of sex. So it could be either that it disproportionately affects men, right? Or that there's intentional discrimination against men or women. So it would have to be that kind of case. Intentional discrimination is required generally under constitutional claims or discriminatory purpose. There's a little wiggle room there, discriminatory purpose. So it might be that we would have to get legislation from Congress that allowed for a disparate impact claim. That's actually being contested now, I think so.
Paula, for our viewers, you've used the term intersectionality. Would you please define that for our viewers?
Yes, I'd be happy to. So what Alice Paul did in 1920 was to say to African-American suffragists, yours are racial issues, you know, ours are issues of sex. And that's an artificial distinction. And we now understand that, especially in legal scholarship and legal theory. There was a law professor, Kimberly Crenshaw, who sort of described this phenomenon as intersectionality, that your disadvantage because of your race and because of your sex together create even more disadvantage, a different kind of disadvantage. So that's the concept of intersectionality. And when we look back at 1920, that's exactly what Alice Paul was using as a tactic to push off the request to help African-American suffragists by artificially splitting those. And now, you know, today we say, no, those can't be split, right? They're intersectional in the sense that they amp up the harm that can be done to you based on your race or your gender.
We have a number of young women who are watching. These young women, for example, in the Cook Leadership Academy, we've always asked them to be alert to the leadership lessons of a great book like yours. Could you please share your thoughts on women in leadership and what you learned about that while researching this book and observing women through your career?
That's part of, again, the real satisfaction in having done this book was to look at the suffragist leaders. And again, I keep using Alice Paul because I think there's really generational kind of interesting aspects for young students today, right, who are studying these issues. She was very young. She was in her late 20s, early 30s when she was fighting this battle. And she was fighting with Carrie Chapman Catt, who was the head of, again, the National American, the big suffrage group, who was much older, 15, 20 years older. And so part of leadership, right, is this struggle between generations. And that's as true of women leaders as it is of male leaders. And I thought that was really interesting. And the other thing was Alice Paul needed that singular focus. That's all she did. If you read the letters from her to other people or the letters from the people working with her to supporters of the suffrage organization, it's clear. They'll say, you know, that's basically all she did. And that was essential in terms of a leadership attribute to getting the 19th over the line, right? And it was important, and it probably wouldn't have gotten over the line as quickly if she hadn't had that singular focus. And obviously if the conservative, you know, the NASA group hadn't been working on it for many, many years and then kind of they all aligned the last 4 years for a federal amendment. But once it was over the line, her inability, right, to kind of broaden that lens, and maybe we can't expect that in the same leader, right? That those are the attributes that you need for leadership for one movement, and then it was not so adaptive for this other movement. She wanted immediately to pivot to the ERA, and she fought with the legal lights of the time, people like Felix Frankfurter, who was a professor at Harvard at the time, Florence Kelley, and they just battled about the ERA, trying to negotiate the language because, again, the progressives like Frankfurter and Kelley were deeply afraid that the rather conservative Supreme Court would use it to strike down protective legislation. And so that attribute of singularity, singular focus was so important to getting the 19th ratified, but then it became maladaptive as a leadership quality after the fact. And she got bogged down and tangled up in this, you know, unwillingness to sort of try, which, I mean, she on paper tried to compromise. There were a lot of letters back and forth in meetings, but in the end, she was going to go with the Equal Rights Amendment. And she did. 1923, they stopped all these negotiations, and it went into Congress. So I would say that as a leadership quality is an interesting lesson. And women face, you know, advancement barriers. They face structural barriers. We face gender bias. We face gender schemas about whether, you know, we are adequate to the task in terms of leadership. And so I'd say to my students, you have to find an authentic style that works for you. And if you're authentic, and you can be anywhere on the spectrum, right, in terms of a kind of a top-down leader versus a collaborative leader, what works for you is finding that authentic style is the first kind of step to good leadership, especially, I think, for women.
And that's what, you know, young women like Camila, who spoke earlier, I think are going through right now and defining that for themselves, watching you and other women who have been there before her. Another interesting question coming in. This is always an interesting question. So the viewer is asking, now that critical reviews of your book are coming in, has that made you want to change anything that you wrote in the book? Critical in the sense of scholarly.
Yes. So I think that it's not that I would change anything, it's that I would add more about the issues around the role of that Congress played and in this whole kind of story. So I'd like to expand it, and I hope in future writing, law reviews and things like that, to really focus even more on the other actors, because as you said, it's a multi-institutional story. And this book focuses on the suffragists. And I tried hard not to blame the suffragists. That's one thing that I don't want people to take away when they read the book. And I want to say they did amazing things after 1920. They just didn't do it around the 19th. They went to state legislatures. They lobbied for legislation to strike down discriminatory laws about women. They did it in those state legislatures. They did it on the ground. You know, the National Women's Party eventually succeeded in getting 300 pieces of legislation in various states through that improved the condition of women to own property, to make contracts. I mean, they did amazing work. The League of Women Voters to this day does amazing work in voter education, right? And so, you know, I think that's an important piece of the book. And so maybe I would even emphasize that more if I were to go back and do it. So that might be another thing that I would like to go back or actually do in the future. I think talk more about that and more about the role of Congress.
Well, that actually segues to one last question we'll have time for, and then we're gonna have to pitch it back to Jacob. But here's a question. Do you have another book in you? And if you do, what is it going to be? And maybe you just answered it.
Yeah, so it would involve the role of women lawyers in constitutional equality, sort of the definition of constitutional equality. And we forget that women, you know, were trying to become lawyers as far back, right, as the late 19th century, and they eventually were allowed to practice. And there were many, that training in the law, if you look at these women across time, they played a critical role, not very public, in shaping the Constitution, right? Florence Kelley, for example, and Alice Paul. There were women later on who have not gotten a lot of publicity, and that training in the law is so important. So I would encourage all the students who are listening, think about law school, right? You can make systemic change if you understand how the system works, and that's what law school gives you. So I think that would be something that I'd be really interested in writing about, the role of these women as constitution makers and as definers of equality under our Constitution.
We'll look forward to that book, and we'll have you back on.
Thank you.
Professor Paula Monopoli, thank you so much for being such an engaging and enlightening teacher to us tonight. We really appreciated having you here. It's been an honor. Thank you. And I'm going to pitch it back to Jacob now.
Thank you, Gleaves.
Thank you, Professor Monopoli and Gleaves, for that wonderful discussion. For those interested in purchasing a copy of Constitutional Orphan, Professor Monopoli has generously provided us with a link for a 30% discount, which will be posted following my remarks. We hope to virtually see all of you again for our next event on Friday, October 9th at 4 p.m. over Zoom webinar. Dr. Eva Feldman will join our students in the Leadership Academy for a wheelhouse talk that bridges science in the lab with clinical science with patients, sharing lessons in a trailblazing medical career along the way. Once again, thank you all for joining us this evening. Have a good night.